Hello and welcome to GBLA's third Thursday. We are excited today to have you here join us. We have one of our project attorneys, Cynthia Bradshaw, on the line today to help us go over our guardianship projects here at GBLA. Just a couple quick housekeeping rules. You are automatically muted and your cameras are off during the course of this presentation. If you should have any questions throughout the presentation, please feel free to either use the raise your hand feature, type into the questions, or the chat box. I'll be reviewing those throughout the session. This will be recorded today, and the information will be provided on our and posted to our YouTube channel. So if you are here with Third Thursday with GBLA for our guardianship projects, you are in the right place. So with that, I'm going to go ahead and introduce Cynthia, and she's going to take over from here. So give us just a moment. So you should be able to share your screen now.
Okay, thank you, Cassie. Are you able to see my screen?
Yes, but we currently see your desktop.
Okay, let me move it into this window. Okay.
Perfect.
All right, great. Okay, hello everyone. I'm Cynthia Bradshaw. I'm an attorney here at GBLA. I work in the Grandparent Guardianship Project and as well as our volunteer attorney program. So this afternoon I'm going to be giving a presentation on guardianship and the guardianship programs at GBLA. So to get started, the information that we're providing today, it is for informational purposes only. It's not intended to create any sort of attorney-client relationship. And if you do have any specific questions about your own situation, it's best to speak to an attorney so that way you have some tailored legal advice. Okay, to get started, we're going to be going over what a guardianship of the person is, who can become a guardian, is guardianship necessary, discussing alternatives to guardianship, which include a caregiver's affidavit and power of attorney, some of the rights and duties of guardians, the difference between probate guardianships and juvenile dependency, public benefits for guardians, and then going over the GBLA guardianship units. Okay, so guardianship of the person. Guardianship, what it does is suspend the parental rights so that someone other than the parent is able to care for the child, have custody and control of the child, and be in charge of the child physically and legally. It does not permanently terminate parental rights, it only suspends them. That's a distinction from an adoption that does suspend, it does actually terminate parental rights if it is an adoption. The parent does retain rights to visitation that can be subject to a court order, and the parent does maintain the obligation to financially support the child in a guardianship. Guardianships can be obtained either through probate court or juvenile court, which could be a dependency or delinquency case. At GBLA, we do practice in the probate court and we do probate guardianships. At this time, we do not provide services for juvenile court cases, juvenile dependency or delinquency cases. A guardianship is valid until the minor turns 18, they become married, emancipated, adopted, or it's terminated by court. And the court grants a guardianship when it appears necessary or convenient to do so, and that is found in the probate code. That's the standard that the court will use to determine whether or not a guardianship is necessary. Okay, so who can be a guardian? A guardian, it's an adult appointed by either the probate court or the juvenile court to take care and custody of the child when the child's parents are unavailable or unwilling to take care of the child. It can be a relative or non-relative that's appointed as the child's guardian, and in general, this person is to ensure the child's best interests. And again, going back to that distinction between a probate guardianship and a juvenile dependency guardianship, there can be different access to different financial resources. And generally in a probate guardianship, there are fewer financial resources available. So now moving to, is guardianship necessary? Some of the advantages of guardianship is the caregiver has legal authority over the child. It creates stability and consistency for the child. It provides protection for the child. It allows the child to be placed on the private medical insurance of the guardian. The guardian's able to consent to special education for the child, and they can obtain certain public benefits for the child. Some of the disadvantages of guardianship can be the time and expense. Generally, if someone may qualify for a fee waiver, they may not have to pay filing fees. Otherwise, there are expenses associated with guardianship. It may create stress and conflict between a parent or caregiver. It may not be in the child's best interest, and it may trigger a referral to Child Protective Services. One thing to also note is guardianship is not necessarily an appropriate tool for planning for care of a child after the death of a parent, or to give a step parent any sort of authorization or rights to the child. So some of the alternatives to guardianship, there are rights of informal caregivers. Parents can grant rights to an informal caregiver. This would allow them to enroll the child in school, to make certain medical decisions, allow them to receive some public benefits for the child. But one thing that I will mention is with these alternatives to guardianship that give these rights to informal caregivers, they're not court orders, so they do not prevent the parent from removing the child. So if it's a situation where there may be some concern for the child's well-being or safety, an informal agreement is not going to prevent that child from being taken from the caregiver. So again, some of the alternatives to guardianship, there are child care authorizations that can be used by related caregivers. This is found in the family code, as well as a caregiver's authorization affidavit. And with these agreements, under the first option, the child care authorization, it allows the parent to authorize in writing for an adult who's able to care for the child, to provide for medical, dental care for the child. And again, it's an authorization that can be terminated at the parent's will. So again, if it's a situation where the parent decides to revoke this authority, that's something that can be freely done. Okay, and then with the caregiver's authorization affidavit, this allows for school enrollment. It allows the caregiver to enroll the child into school. It allows them to receive certain medical care for the child. This can be immunizations, physical examinations, if it's the purpose of enrolling the child in school. However, it doesn't allow a consent for special education, and it doesn't transfer school records unless it's done by the person who has educational rights. And again, continuing on with the caregiver's authorization affidavit, the parent has to be notified if they're not able to be located, and it has to be a qualified relative who is executing this caregiver's authorization affidavit. So qualified relatives, that's a spouse, parent, step parent, it can be a sibling, aunt, uncle, niece, nephew, or any person who's denoted by the prefix of grand or great, or it could also be the spouse of any of these individuals. And as I mentioned before, this does allow for the caregiver to make medical decisions that are school related. And again, that would include medical treatment that's necessary for enrolling the child in school. Okay, another alternative to guardianship is a power of attorney. A parent can designate a third party to make legal, medical, and financial decisions in the absence of the parent. It does not terminate the parent's rights, and it can be rescinded at any time. It can become effective either immediately, or it could be effective on a triggering event, but it is very limited. And again, as I mentioned, with these alternatives to guardianship, they're freely revocable at any time. Okay, so now turning to some of the rights and duties of a guardian. So all the rights of a guardian are outlined for probate under Form GC 241, it outlines the care, custody, and control of a minor. So a guardian decides where the child lives at. The guardian is able to move within the state of California, but proper notice must be given of any change of address of either the guardian or the child. If the child is going to live outside of the state of California, then the court must grant permission for that to occur. And that has to happen before. So a guardian can't move out of state until getting that approval from the court after petitioning. A guardian is responsible for the child's education and holds the educational rights. That includes decision making, if there are any special education needs that the child has, or if there are any related services. The guardian is the person who is to advocate for the child within the school district and make any appropriate arrangements. The guardian must follow any court orders that there may be regarding visitation. They can consent to a driver's license for the minor once they become of age. They can consent to enlistment in the armed services. And if the minor is to marry before the age of 18, that is a decision that requires not only the guardian's consent, but also the court must approve that decision as well. So a guardian may consent to medical treatment with some exceptions. They can consent to surgery on a child, but if the child is 14 years or older, they must also consent. They may consent to some medical treatment on their own, the minor. The guardian is not able to consent to the use of any type of experimental drugs for the minor, and the guardian may secure counseling, but the child may not be placed in any sort of mental health facility against their will. So a guardian, like a parent, is liable for any harm or danger that's caused by any willful misconduct by a child. There's usually a limitation on how much the guardian may be required to pay, but there are different rules that are outlined specifically in the civil code section that I've listed here that explain exactly what a guardian would be liable for, and that does inference any use of a firearm by the minor. So financial support of the minor, as I mentioned before, the parent does still have an obligation to financially support the child, but absent the parent, or whether the parent is contributing or not, the guardian still has a responsibility for the day-to-day financial support of the child. And as I mentioned as well, there are some public benefits that may be available to the guardian depending on their eligibility status. If there are 2 or more guardians that are appointed, they both must agree on all decisions to the child. There's no one guardian that has more power over the other. The guardians are to make all decisions together, and if there's a situation where the guardians are in conflict, then they may seek guidance from the court on the decision. There are certain special orders that the court can make that can either expand or limit some of the powers that we've discussed. Okay, so a very big area that we're going to cover is the difference between probate guardianships and juvenile dependency guardianship. Juvenile court takes precedence over probate court, so meaning any order that would come from the juvenile court would automatically supersede any order that comes in probate court. In dependency cases, these are usually the result of a call made to a child abuse hotline, a CPS investigation where there's been a case opened under Welfare and Institutions Code 300, and they may refer parties to probate court if there's not either sufficient evidence or there's no need to move forward in the juvenile dependency case. And as I mentioned before, here at GBLA, we do practice in probate. So all guardianships that GBLA is able to assist with are through their probate court. So starting with the petition process, in probate court, a person who wants to be appointed as the guardian of a child must file a petition with the probate court. So the child's parents or the child, if they're at least age 12, can also file a petition. In juvenile dependency, to start a juvenile case, it's a county social worker or prosecuting attorney must file the petition in juvenile court. So In probate court, as far as investigation, before the court decides to appoint a guardian, an investigation is usually required. If the proposed guardian is a relative, a court investigator conducts the investigation. So here in Kern County, it would be Family Court Services. If the proposed guardian is not a relative, then a county social worker conducts the investigation. So in Kern County, that would be Department of Human Services. So the investigator prepares a report and makes a recommendation to the court on whether or not the petition should be granted. In juvenile dependency, the social worker or a probation officer conducts an investigation to determine whether to detain the child temporarily out of the parent's home or whether to recommend that the court remove the child from the parent's home. A person who wants to serve as guardian in this case could contact the social worker, the probation officer early on in the case to let that person know that they would like the child to live with them. So appointment of counsel. In the probate court, the court has the authority to appoint an attorney to represent the child. The court also can appoint an attorney for an Indian custodian or a biological parent of an Indian child, but it doesn't otherwise have the authority to appoint counsel for a parent. Differently in the juvenile dependency type of guardianship, in a dependency case, a juvenile court must appoint counsel for the child unless it finds that the child would not benefit from the appointment. Usually a case where the child would not benefit is if they are, a smaller child or an infant. And almost in every case, the court will appoint counsel for a parent who cannot afford counsel themselves. Similarly, in a juvenile justice case, the court may appoint counsel for the child if the child does not have counsel, and the court may also appoint a separate counsel that is available to represent the parent. So the hearing process in probate court, the court holds a hearing to decide whether to appoint a guardian. A parent or other interested person may go to the hearing and object orally or in writing to the appointment of the guardian for the child. And the court will decide whether appointing a guardian is necessary and in the child's best interest. So going back to that standard that we discussed before, whether it's necessary and convenient, that's what the court is determining at that point. One thing I will also note, a parent or other interested party may object to the petition. So that can be perhaps the child's grandparents or other interested siblings, aunts or uncles. Those are typically the other parties that we would see object to a guardianship petition. So in the juvenile dependency guardianship, the court would hold a hearing to decide if the petition is true and whether to order the child placed out of the parent's home. If the court does decide that the child can't live safely at home, the court would appoint a guardian right away if the parents do agree to that and the child is of age and can agree. If that is not the case, that agreement is made. Instead, the court would order the child placed with a foster parent or resource family and order the social worker or probation officer to provide reunification services for the parent. So with the idea of reunification services, that's where a permanency plan would be developed for the child, and that could be either returning back to the parent, being placed in a long-term guardianship, or possibly adoption. Okay, so reunification services in probate court, the probate court cannot order family reunification services, but it can order supportive services for the guardian and child if needed. The probate court does not have an emphasis on reunification, whereas in the juvenile dependency guardianship, there is a reunification emphasis. They can order services to help the parent and child reunify before it chooses a permanency plan. And again, a permanency plan that can be guardianship, it could be long-term foster care, it could be returned to the parent, it could be adoption. Okay, so in probate court, the decision to appoint a guardian, if the probate court finds that the appointment of a guardian is necessary and in the child's best interest, then the court may appoint the guardian. In a juvenile dependency type of action, the juvenile court may appoint a guardian at different times during the case. After making the required findings in a dependency case, if the court finds it's in the petition is true, it can appoint a guardian for the child at the dispositional hearing if the parents and the child agree. And again, this is how we discussed before that if there's an agreement, there can be a guardianship established at that point. Otherwise, the court is going to move towards the focus on reunification services and offering the parent different services that they need to either reunite with the child or possibly look at other permanency plans. Okay, so probate court with court oversight, after a guardianship is appointed, there are no regular court hearings in probate court. The probate court does have the authority to regulate and control the guardian's actions. The court can order that the guardian allow visitation of the child with the parents and other persons. The court may order the guardian to submit annual status reports to the court, and depending on the county, the court may hold a hearing. So typically a guardian would receive a request for status report on a yearly basis from the court. The guardian in that status report is essentially giving the court an update on how the child is doing, how the child is progressing in school, their medical, dental, if there are any concerns of the court. And typically we're looking at, if the child is not doing well in school or if there are any medical concerns, then the court in that case can hold a hearing where the guardian physically goes into court and makes a report, but otherwise there's no court oversight in probate. In juvenile dependency guardianship, the juvenile court keeps jurisdiction over the guardianship, and when the court appoints a guardian, it must also issue parental visitation orders at that time unless it finds that the visitation would be detrimental to the child. In many cases, after guardianship is granted, if the guardian is related to the child, the court will terminate the dependency or juvenile justice jurisdiction and will not hold any regular hearings. But after the jurisdiction is terminated in a juvenile case, the court can give orders to the guardian, and any requests for any changes to those orders can be made by a filing to the juvenile court, and that's with using a form JV 180. Okay, so terminating a guardianship, the guardianship is automatically going to term by operation of law when the child turns 18. It could terminate before the child turns 18 if the child dies, is emancipated by court order, gets married, joins the armed forces, or is adopted. If the guardian, a parent, the child, an Indian custodian, or the child's tribes, if they are a member, shows that it's in the child's best interest, and the court can terminate a guardianship before the child turns 18. The longer the child has lived with the guardian, it's harder to establish that it would be in the best interest to terminate the guardianship because the court is looking at stability of the child and what's in the child's best interest. If the child consents, the court can extend the guardianship after the child's 21st birthday to let the child complete a federal application for special immigrant juvenile status. So turning to juvenile dependency guardianships, that would also terminate when the child reaches age 18, same circumstances as a probate guardianship. The court can terminate the guardianship if it finds that there's another permanency plan that would better suit the parties, such as adoption, if that's in the child's best interest, a social worker or probation officer, the guardian, a parent, the child, an Indian custodian, or the child's tribe can file a request with the juvenile court to terminate the guardianship. Okay, termination of parental rights. So with probate court, as I mentioned before, with the probate guardianship, it suspends parental rights. It doesn't terminate them, but under the probate code, if a child has been living with the guardian for at least 2 years, the guardian can file a petition to terminate parental rights so that the guardian can then adopt the child. The parents are entitled to appointment of counsel if this happens. So any time there's a possibility of termination of parental rights, that triggers the right to have a counsel appointed. In some situations that are specified in the family code, the guardian can ask to adopt the child after as few as 6 months have passed, or they may need to wait up to 3 years. If the child is an Indian child, the Indian Child Welfare Act requires different procedures. So in the juvenile dependency guardianship, when the juvenile court is going to terminate parental rights and change the permanency plan to adoption, that is usually the termination of parental rights that we would discuss in this area. The court will hold a hearing to decide whether to grant the request. Each parent is entitled to notice of the hearing, to participate, and again, to have an attorney appointed to them. And again, as I mentioned, whenever there is a termination of parental rights that's possible, that triggers the right to have the attorney. If the child is an Indian child, the Indian Child Welfare Act would require different procedures. Okay, public benefits. So the availability of public benefits depends on the type of caregiver arrangement. So typically, as I mentioned before, probate guardianships usually have fewer benefits available, whereas the guardianship that's granted through juvenile dependency court, that usually comes with different benefits that can be obtained through the foster care system, CAN-GAP, whereas with a probate guardianship, it's usually going to be public benefits that are available, cash aid assistance, food stamp benefits. The child may also be eligible for Medi-Cal benefits, Social Security, depending on if the child may be a disabled child, and the level of the payment amount, it depends on varying things. Usually when we refer our clients to seek public benefits, we refer them to work with a worker at Department of Human Services that's able to help them assess what they're eligible for. Okay, so turning to the GBLA guardianship units. So the Grandparent Guardianship Caregiver Project, again, that's the project that I work in as the staff attorney. So we handle probate guardianships. For eligibility purposes, clients must reside in Kern County, must be aged 55 years of age or older at the time of the appointment, must be related to the child either by blood or through marriage. The child must be living with the potential guardians, and the potential guardians must be the primary caregiver of the child because the parent is either unable or unwilling to serve as the primary caregiver. We also have our First 5 Guardianship Caregiver Project. So again, we handle probate guardianships. At least one child involved in the guardianship petition must be age 0 to 5. The potential guardian must reside in Kern County. They can either be a relative or non-relative caregiver for this program, and the primary caregiver of the child must be because the parents are either unable or unwilling to serve as the primary caregiver. And then lastly, we do have the volunteer attorney program. So again, probate guardianships must reside in Kern County. Under this program, the potential guardian can either be a relative or non-relative. The child must be living in the household, and the potential guardian must be the primary caregiver of the child because the parents are either unable or unwilling to serve as the primary caregiver. And for all 3 units that I mentioned, anyone who is interested or potentially receiving services through one of these programs is encouraged to contact GBLA to speak to our intake staff who can assist you with assessing your eligibility for these programs. Okay, I'll move on to questions now.
So at this time, you can either click the raise your hand option in the box, or you can use the questions or chat. And I don't see any at this time, so we'll give it just a moment in case anybody does have questions. I'm not seeing any hands raised or any questions in the box at this time.
Okay, well, if there are any other questions, I'm more than happy to answer off screen.
Yeah, I don't want to see any questions or any hands up.
Okay, well, I went ahead and put up our contact information. And again, if anyone is interested in seeing if they're eligible for services or has more questions, please feel free to give our office a call. Our contact information is listed. Thank you.
Cynthia, thank you so much for the great information. I hope you guys all found some value in the information that she presented today. As of course, as she lists on the screen, feel free to give us a call anytime you'd like to apply for assistance. And if you do have any questions after we end this presentation in a moment, feel free to reach out to me directly. The email that you registered with, it would have sent you my email address. And if not, you can always find me at kmullican, MULLICAN @gbla.org. But thank you so much for spending Thursday afternoon with us. I hope you found the information valuable, and we'll see you next month.